Good morning, Ms. Merman. Mr. Batten, good morning.
Good morning, Your Honor, and may it please the Court. My name is Mark Batten, and I represent the Globe Newspaper Company in this further appellate review matter. From the very beginning of this case, by which I mean the second sentence of his Superior Court complaint, Douglas Godfrey sought to force the Boston Globe to grant him an accommodation for his disability that the law simply does not require. The second sentence of his complaint, and repeated again in his prayer for relief, was, direct the Globe to give me a job that doesn't require climbing on the presses, the newspaper presses, which are 3 stories tall. There simply is no dispute in this case, no contrary evidence on either of the 2 critical points that are dispositive of this appeal. First, that climbing, standing, kneeling, those kinds of physical activities are essential functions of the assistant foreman job that Godfrey held. And secondly, that Doug Godfrey, despite his best efforts and those of his doctors, simply is not able to perform those functions.
Well, you say there's go ahead.
Well, just to fill in some facts, you say the Globe was not required, but had the Globe accommodated other people in the past?
There is no evidence, Your Honor, beyond, well, at most, the evidence was 4 or 5 people over the course of some 25 years. And of those 4 or 5 people, no evidence.
So where the Globe was not required to but did accommodate?
Well, no, because there is not competent evidence in the record that those individuals were injured and that those adjustments were made as a result of injury. The closest that we got to that was the testimony of Christopher Francis, who said that he once saw one of the individuals who was allowed to work on payroll wearing a knee brace, but no other evidence of that.
But you say that climbing in and out is not an essential function of the job. He says that it is.
It is an essential function, Your Honor.
I'm sorry, you say it is. He says it isn't, that
Correct.
he couldn't supervise other people doing it. Isn't that a fact question that is disputed, and it's a material fact?
No, Your Honor, for 2 reasons. First of all, Mr. Godfrey's response to our statement of undisputed facts at summary judgment squarely admitted, said it was undisputed, that climbing on the presses was an essential function of the job.
Yes, because he doesn't want that job, right?
I'm sorry, Your Honor?
He does not want that job. He wants another unspecified job. In other words, he is not asking for a reasonable accommodation to perform the functions of the job. He is asking for a different job.
That's precisely right, Your Honor. It has been since the opening salvos of his complaint, because he acknowledges that he cannot perform those functions. To finish the answer to your question, Justice Cowen, in addition to his admission in the summary judgment papers, the evidence was also absolutely undisputed that climbing is an essential function. Every witness who knows anything about the presses and was asked that question categorically said, you have to be able to climb. That's what the assistant foreman does. He adjusts the tension of the newsprint that's going through the papers and that has going through the press, and that has to be done on multiple levels. Christopher Francis testified to that. David Stenstrom, the
Could he not direct someone else to do that? For example, I think I read that he was called at home to give his opinion about how to fix certain things while he was out ill. Could he not direct other people, you climb up and do this and do that and do the other thing?
He could, Your Honor, absolutely. And there's no question that in any disability case where the plaintiff's status as a qualified handicapped individual is at stake, the employee could always argue, well, you can get somebody else to do that. But the law in Massachusetts and elsewhere is, but particularly under 151B and its statutory definition of an appropriate accommodation, is that the only accommodations an employer has to make is one that allows the employee himself to perform the essential functions of that position.
Can I ask you this? You say that the only relief sought is a new job, but there is laced throughout the briefing in the case, this notion that he sought another accommodation in the spring of, what was it, 03, when he was returning in June or thereabouts, and that is a shorter workday.
Yes, Your Honor.
Is that in this case? Is it not in this case?
Well, if I may, I think the reason for your uncertainty is that it was not an issue in the case in the Superior Court.
Okay.
It became an issue in the appeals court. But let me address it squarely.
All right.
The evidence in the case is that when Mr. Godfrey tried to return to work in June of 2003, he brought with him a doctor's note that said he could not work more than 5 hours per day. And he provided that note to the Globe. The evidence is also undisputed that over the following 6 or so weeks until mid-July, he was permitted to work as much or as little as he wished, an accommodation that we would say was far in excess of what the law required. He testified that he didn't work even 3 days a week. He has no recollection whether he even worked a full shift on the days that he did work. And he also testified that he didn't recall having any difficulty leaving early, getting any kind of criticism or prohibition from any supervisor to leave early when he needed to.
So then what happens? So he's back in June or July. He's sort of working intermittently. I know he's fired in August, and I know he's fired, the Globe says, for a completely different reason. But does he also stop working?
He does, Your Honor. July 21st, 2003, he testified in his deposition, I just couldn't do it. He couldn't do the work. And he also submitted an affidavit, Your Honor, which is in the record at 122, saying that his doctor ordered him to stop work on July 21st, and that's why he stopped. But in either case, he was medically unable to continue at that point.
So when does he request an accommodation after that? When does he request this different job? Is that a year later or something?
Yes, Your Honor. Not until December 2004, more than a year after he's been fired, he sends a letter fired for theft, incidentally. He sends a letter into the Globe saying, I'd really like to come back to work, but I'm going to need a position that doesn't involve climbing on the presses. The Globe declines. The reason that it declines is because he was terminated for theft.
Could I just ask you a question about that? I'm sorry, did you finish?
Yes, Your Honor.
How did it happen in the Superior Court that the case totally was resolved on this issue of disability as opposed to the articulated reason for the termination?
We presented two arguments to the Superior Court, Your Honor. First, that Mr. Godfrey could not make out a prima facie case because he wasn't a qualified handicapped individual. And secondly, even if he was qualified and therefore entitled to some accommodation, he was fired for a completely different reason as to which there was no showing of pretext. Because the Superior Court disposed of the case at the prima facie case stage, there was no need for the court to reach the second argument.
So, but given that that was the reason articulated by the Globe, and maybe I'm just not, I don't understand the record well enough yet, but the subsequent medical reports from various doctors about how Mr. Godfrey could do this job now, or 2 years later, a year and a half later, was the Globe still having him examined?
Yes, Your Honor, not for this purpose, but because
why?
If
you terminated him for cause, that's what I just don't get.
He was receiving workers' compensation benefits, and there was, and after that...
And they continue even if somebody's terminated for cause?
And disability benefits, yes, Your Honor. And so there were
Yes.
medical benefits, medical examinations that were being conducted in the course of that proceeding, which subsequently became evidence in this matter.
On that subject, did you do anything about the fact that the plaintiff retained his weekly compensation checks from April of 2002 to August of 2003?
In terms of what the Globe did, when it discovered it, it terminated him, and then the record suggests that he repaid those amounts in the course of a settlement of the workers' comp disability proceedings.
But did you do anything during the time period of April 2002 to August 2003?
No, Your Honor, because the Globe was not aware that was happening.
So that's how you answer that you weren't. How did you become aware of it?
There was a report, Your Honor, that may have been going on, which prompted an investigation by the Human
And that
Resources
report
Department.
didn't come to your attention till sometime in 2003, is what you're saying?
In August, that's right, Your Honor. The
Okay.
investigation was quickly conducted, and the result, both as to Doug Godfrey and to his brother Robert, who was similarly called in and admitted that he had stolen this money, the result was the same.
So this case, I take it back to the reason, the disability question, or handicap question. This case really turns on, I take it, the difference between our law and the federal law. Is that, I mean, in other words, because your argument is under 151B, there is no requirement that you find another job.
Even under federal law, Your Honor, there's no requirement that you find another job. Reassignment, the reassignment obligation may be broader under federal law, but even there, the position, there has to be a vacant position into which the plaintiff could be transferred. And
Okay, but here, you don't even get there.
we don't even get there, that's right, because the language of 151B itself, which says that a qualified handicapped individual is someone who can perform the essential functions with or without accommodation of the position involved. That's the quote. And this court held in Russell versus Cooley Dickinson Hospital specifically that because of that language in the statute, which was modeled on the Rehab Act and passed before the more expansive Americans with Disabilities Act, the court held in Russell that finding another position for the plaintiff, even if one is vacant, is not required.
And one final question, just following up on Justice Cordy's question to you, because I think the Superior Court, Judge Troy, says something about this. When Mr. Godfrey came back in June with the letter saying I can't work more than 5 hours a week or 5 hours a day, and the judge says, but you don't even get there because he wasn't qualified. Is the reason for that you would say that even within 5 hours you still have to climb, and as long as you can't climb, you can't, shortening the hours doesn't even help? Or is the reason that you did shorten the hours and then he said I can't do it even in these shorter hours, or both?
It's really both, and there's one more thing to be said about that, Your Honor. First of all, climbing is required throughout, and he couldn't do it even on the reduced basis that the evidence suggests he was allowed. He made that his own judgment on that, and his doctors made that judgment. But also, as we argue in the brief, the role of the assistant foreman is to supervise and to monitor the tension and the ink flow and the other things on the press throughout the shift. So that's why I said before that an accommodation of a reduced schedule is not reasonable in this case, because someone has to be supervising that press. And if Mr. Godfrey can only do it for 5 hours, and the shift runs significantly longer than that, the Globe's going to have to get someone else. There's no evidence in the record that the press could be left unsupervised for the balance of the shift.
Okay, but that becomes, maybe this is a technicality, but that becomes not so much that he's not a qualified individual with accommodation. That becomes that the accommodation suggested is unworkable, unreasonable.
No, Your Honor, we would say it's actually both, because it is an essential function of the position that the assistant foreman be able to monitor that press throughout the run. Someone has to do it. It's an essential function.
And that means he has to be there throughout the run.
And that means he has to be there. It's,
okay.
Attendance sometimes is an essential function of the job, and that's true here, where it's not a matter of simply setting up the press and then pushing a button and everybody goes to lunch and watches the newspaper get printed. It is a constant monitoring process. There's always the potential for, and frequently the actuality of, a problem with the press, as to which the assistant foreman is the lead man. He is to climb in to the press, figure out what's wrong, and fix it.
Counsel, I have two questions. Is it your sense or position that we could proceed to decide this case on the ground that the judge did not decide it on, and that is that the termination was for a completely unrelated cause and there's no evidence of pretext such that a jury needs to decide?
Yes, Your Honor, on the very familiar principle that the court can affirm for any reason.
But the record is sufficient on this point, in your view, to actually make a summary judgment decision in that respect?
Yes, Your Honor. Contrary to what the appeals court said, the theft question was extensively briefed below. Discovery was fully complete at the time summary judgment was filed. It was 50% of the brief that we filed before the Superior Court. There's no question about that.
And 50% of Mr. Godfrey's, I mean, he addressed it too.
Oh, absolutely, Your Honor.
I take it, Mr. Batten, that that was also briefed in the appeals court?
Yes, it was, Your Honor.
So, for some inexplicable reason, the appeals court, having reversed you on the first one, did not go on to address what may be an entirely meritorious claim on the second.
Yes, Your Honor, saying that the record was undeveloped and that the Superior Court hadn't addressed it.
One last question for me in any event. You say that it's undisputed that the plaintiff's position here required this physical activity. he says no. He says that that the job of a pressman required that, but he was an assistant foreman, and that didn't require that, and that you're looking at, you're mixing apples and oranges. I haven't looked at the record sufficient to sort of gauge that argument.
You will find, I think, when you look at the record, that there is zero evidence of that. Mr. Godfrey himself testified in deposition that he was climbing on the presses just as much as a foreman as he was as a pressman, and the others who testified about it, including his friend, a different foreman, said it's impossible. He couldn't even carry, he was asked, I know my time's out, but he was asked at one point, could he carry a British hunting stick, which unfolds and he can make a seat out of it. And his friend, another foreman, said, it's just not workable. You can't do that.
Thank you.
Thank you, Your Honor.
Thank you, Mr. Batten. Mr. Melly, good morning.
Good morning, Your Honor. May it please the Court, my name is Paul Meary. I appear today on behalf of the plaintiff appellant, Douglas Godfrey.
Mr. Melly, could I ask you this question? With respect to the pretext piece of the argument, why is this case not governed by ocean splay, and what evidence is there in the record to suggest that this takes your case out of Matthews against ocean splay, where you will recall there was also a termination for theft?
Well, Your Honor, first of all, to address the Court's last word, there's no evidence that this is theft. This is not theft, Your Honor. The record is clear that what happened here, and I don't think the Superior Court got to it, but what is clear here is that there was an overpayment. Now, there had been overpayment.
Did your client return, pay into the Globe the workers' comp payments that he was receiving, although he was also receiving his full salary while he was out on medical leave?
He repaid certain months, the first several months. May I back up?
Is there any dispute that he knew that he had to make those payments?
There is, Your Honor, very clearly.
I thought his testimony was that he had overlooked it, he'd forgotten it, that he wasn't in charge of the finances at home.
Those factors also played a role, Your Honor, but the record is clear that when it... May I back up, Your Honor? There was no, at that time at least, that we were aware of, and that Mr. Godfrey was aware of, any explicit written policy concerning this salary continuation benefit that the Globe extended.
Why do you need a written policy? If you're receiving workers' compensation payments and your full salary?
Well, Your Honor, he assumed that that the Globe would take care of reducing his salary to offset the compensation that he was receiving.
He presumably knows what his salary is. It's not as if it's a one-month payment. He knows what his salary is. He receives whatever it is, $500 a week, and he's continuing to receive $500 a week.
And when he continued to receive that money, Your Honor, he was curious. Let me back up just to clarify. That happened, that first became apparent while he was under extreme pain medication, and he did refer to this, I think that this is in the record, which went on for several weeks, and during that time period he relied on his friend and companion to address that problem. But when he became cognizant, he made a special trip, even though it wasn't working, he made a special trip to the Globe and spoke to a supervisor, and the supervisor said, this is the way the Globe rewards or handles or deals with its management personnel.
Assuming that is all correct, and construing every fact in your client's favor, why is that the basis for a discrimination suit as opposed to a breach of contract, wrongful termination, breach of good, fairness, good faith and fair dealing?
Well, that starts, Your Honor, if I may, because the Globe refuses to allow his request for accommodation even before they were aware of the overpayments.
What accommodation was he requesting?
At that time, Your Honor, he presented a note from his pain doctor, Dr. Geller, saying that he needed to have his hours reduced to 5 per day. That note was presented. The person who got hold of the note tore it up, and he was told, if you can't do the whole job, don't even come in.
So the reasonable accommodation, you say, that is undisputed is that he would, how long is it a regular shift?
Well, Your Honor, it's supposedly 8 hours. But
Okay,
these
so
people-
his reasonable accommodation is, I cannot work 8 hours, I want to work 5 hours.
That's correct, Your Honor.
Was he asking to work 5 hours at the same level of compensation?
Your Honor, I don't think they got to that point, which if the Globe had responded to its obligation to engage in the interactive dialogue, they might have gotten to that point, and that issue might have been addressed.
But Mr. Mary didn't, Mr. Batten says, and that it's my memory, that's, well, certainly, he came back in June. He actually didn't leave until July. Isn't there some evidence that his doctor said he had to leave, and that in that intervening month, he wasn't working full shifts?
There may be evidence to that effect, Your Honor, but that would have been on an informal basis, and he certainly did appear. He certainly did do some functions on behalf of the Globe. So if you're suggesting that that's a tacit accommodation, perhaps there's no reason why it shouldn't have been continued instead of his being told that he had to go home.
But then he has to leave again at the end of July. His doctor says you can't do this anymore.
Yes, Your Honor, that's true. He was continuing to have difficulty with his recuperation from the reconstructive surgery.
And then he asked for a different accommodation, didn't he?
He did, Your Honor.
And that different accommodation is, give me another job.
Your Honor, I would offer that the point of the disability requirement for...
Is that what he asked for?
Yes, Your Honor.
You mean
He asked
in
for...
December of '04?
Correct,
Yes.
Your Honor. He asked for...
So isn't that the accommodation that we look at?
I think that the court needs to look at both, Your Honor, and be cognizant of the Globe's failure from the initial point to respond, as the law contemplates, to engage in a discussion with him about what accommodation would be possible. And I wanted...
Go ahead, I'm sorry.
Please, Your Honor. I just wanted to say that no employee has the power or the right to attempt to prescribe for his employer what the accommodation can be. This has to be a two-sided dialogue, which is why that word is used. And even if he had asked for a job as the editor of the Globe, I think that the Globe, being on notice of his disability and his need for accommodation, I think the obligation would have been triggered for them to say, all right, well, what accommodation do you need? And we can do this, but we can't do that. And this,
I'm sorry, finish.
and this was, I think, raised earlier, Your Honor.
But wasn't there some discussion going on all the while that he had been injured and was trying to get back to work? He was working part-time, and he eventually said to them, I just can't climb the presses.
Your Honor, not only that, but he actually had been back at work in 2002 doing a light-duty job.
But did he say to them, before he was terminated in August of 2003, I cannot climb the presses, at least for an entire shift?
Well, that was the purpose of the requested accommodation, Your Honor. I don't recall exactly if he said, I cannot climb, or I cannot bend, I cannot squat, but these are certainly substantial impairments of major life activities.
Mr. Mary, let me ask you this. Under Ocean Spray, it's clear that we have to look at people who are claiming to be protected under Chapter 151B. We have to look at the reason that the employer gave for termination. As I understand it in this case, the employer gave the reason that you did not make over to the Globe the workers' comp payments that you will receive. Is there anything in the record that establishes that other employees who had not made over those payments were not terminated?
Your Honor, there is one, a man named Babin.
And when that was brought to the attention of the Globe, was Mr. Babbitt terminated?
He was, Your Honor, but I would suggest that that happened perhaps in part because this case was in
He was
training.
terminated, correct?
He was terminated, correct.
And
Your
there
Honor.
was a second person who was also holding on to his workers' compensation benefits while receiving his full salary. He was terminated, correct?
That you may be referring to Mr. Godfrey's brother, Your Honor.
I just know him as a Mr. Godfrey.
There was another person who received payments and retained them.
So the evidence, other than Mr. Batten, who was then promptly investigated and terminated, there is no evidence that any other Globe employee who kept workers' compensation benefits, even though he was receiving his full salary, was not terminated. Is that correct?
Not that we're aware of at this time, Your Honor, but
Did
I
you
would...
ask for that information in discovery?
I don't recall, Your Honor.
Didn't you have an obligation to ask under Ocean Spray?
If we had an obligation, we would have done so, Your Honor.
Could I ask you a question back on the handicap question? If, back to June of '03, and Mr. Godfrey presents with this letter, but if he agrees, and, you know, in response to the 9AB4 submission of the Globe, I guess he said, admitted, if he agrees that climbing is an essential function of the job of assistant foreman, doesn't that make an accommodation, even for a shorter work hour, as just inapplicable, because you got to climb?
Respectfully, I disagree, Your Honor. It may be that climbing is necessary, but is the kind of thing that someone else could do at Mr. Godfrey's direction. And in fact, as I think the Court observed, Your Honor, this raises the question of what really are the essential functions of a job. And we've, I think, presented in our brief cases to show that the essential functions are the essential functions, the key things that a person has to do. The key things that a pressman or a press supervisor has to do is make sure that the press is running well.
But he admitted it, right? I mean, I'm not putting words into his mouth. He admitted that assertion by the Globe in its 9AB4 statement.
He's not a lawyer, Your Honor, and he doesn't necessarily understand the legal implications of that word.
Did you move to change that?
I did not, Your Honor.
Was he not represented by counsel at the time of the motion for summary judgment?
He was, Your Honor.
Right. I'm perplexed. Assertion 6 on the motion for summary judgment: climbing on the presses is an essential function of the job, both for a journeyman pressman and for the assistant foreman position that Godfrey held. Then, in the Rule 9A-B5 response, signed by you, you say undisputed.
Yes, Your Honor.
So why is there a matter in dispute when you, as the attorney for this is not Mr. Godfrey, a deposition, this is you, on behalf of Mr. Godfrey, on a motion for summary judgment, admitted that point. So how can you argue to us that it's in dispute?
Your Honor, the reason it's in dispute is because, well, I may back up. Whether that's an essential function or not may not be in dispute, but the law requires that a person be accommodated so he can perform the essential functions of the job with accommodation. And that's
it says of a particular job, and I gather that by this you admit that with regard to the particular job of assistant foreman, he can't do it.
He can do it with accommodation, Your Honor.
What accommodation?
The accommodation of other people doing the physical acts of bending and squatting and climbing that his impairment prevents him from doing.
But that means the Globe would have to hire another supervisor.
Not necessarily, Your Honor. The testimony in the record is that there are other members of the crew present in the press room who could follow Mr. Godfrey's instructions in terms of moving
But
up.
I thought the undisputed testimony was that for that position, climbing was essential.
Your Honor, it may be essential, but if it could be done with accommodation, then it's possible for Mr. Godfrey to resume the position.
So your view of reasonable accommodation is that it's reasonable to ask an employer to have an employee forego what is an essential function of the job?
Your Honor, my position is that it's legitimate for an employer to make it possible for an employee who is disabled to perform the essential functions of his job by relying upon an accommodation, whether it be a hunting
but
stick.
You said that climbing is an essential function of the job, and he can't climb. So therefore, you're saying that we should be obligating an employer to say that an employee must be returned to that job even though he can't do what's an essential function. Isn't that what you're asking us to do?
Your Honor, respectfully, what the statute requires is that if a person is able to do the essential functions of the job with an accommodation, then the employer is obligated to return the person to that job. The employer is obviously also obligated to engage in a discussion to figure out what would be a reasonable accommodation and what would be an undue hardship, which, by the way, the employer in no sense even proffered here, that there was any kind of hardship associated with the accommodations that Mr.
So you're suggesting that an accommodation is essentially eliminating the essential function?
No, Your Honor,
he's just saying it's somebody else is doing it. I mean, the job's function is to climb, but he can virtually climb by having somebody do the physical activity for him while he is on the ground. Is that right?
That's correct, Your Honor, and it's not uncommon. In fact, when I was in the AG's office, we had a blind assistant AG who had a reader who read the papers that he had to have, and that's the kind of accommodation that we're thinking of.
But except that here, I take it that it is essential that a supervisor be able to climb the presses at all times during a shift. And when you say somebody else could do it, you're saying, at least in your view, somebody who is not a supervisor could do it, and ergo, the Globe should make that accommodation.
Yes, Your Honor. And
the Globe is saying that no, it's not reasonable to have a non-supervisor act in a supervisory capacity.
my understanding, Your Honor, and again, we're delving deep into factual questions, which is why this needs to be in front of a jury, but my understanding is the kinds of things that the press that necessitate the climbing involve in adjusting the tension of what they call the web, which is the flow of newsprint through the press. This is an adjustment that can be made by anyone under the supervision of someone who knows how to make it, or this is what the evidence would support in terms of a jury finding.
Thank you, Mr. Maley.
Thank you, Your Honor.